Hi, home inspectors. I'm Will Colton. I've specialized in E&O and GL insurance for home inspectors for 15 years now, and I speak with home inspectors about claims and client complaints on an almost daily basis. Some of them even call me on the weekend. There's a significant difference between a customer complaint and what actually qualifies as a claim. So a claim, your insurance policy will actually define what a claim is, and in most cases, there needs to be a demand for money. There's a few other criteria that can do that. You get an attorney letter asking for information, or somebody demands your insurance or tells you you need to report it to your insurance. These types of things can be claim triggering situations. A complaint is literally that. The client's just complaining. They haven't made any monetary demand. They might just say they have an issue and they want your opinion or expertise on it. Now, obviously, the goal for any home inspector is to avoid having a claim. Unfortunately, it's not something that you can always do. So let's say you've actually received a demand for money or maybe an attorney letter from your client. The first thing that you need to do is contact your insurer. That can be your agent directly. There are a few benefits to contacting your Inspector Pro agent early. One of them is our pre-claim assistance program. It starts to deal with those complaints before they become a claim, and we even cut your deductible in half if a pre-claim turns into a claim down the road. So when you contact your insurer, we're probably going to ask you for a few things. So I guess the real question is, how do you report a claim? Well, a couple of ways. One is call us, and then I'm going to ask for some things. The way that I prefer the claim be reported is for you guys to send me an email. That email needs to contain a basic summary of what's going on. Give me your opinion on the matter. You don't have to get too complicated or emotional through that process. A copy of your inspection report and a copy of your signed inspection agreement. After that, it's any other pertinent items, right? Photos, legal summons or demand letters. If you can just kind of put that together and get it to me in an email, then I can forward it to my claims team. Once I send it to my claims team, an adjuster will be assigned and they'll contact you. Through the process, they'll also be your advisor and your guidance. So if you have questions, they're a really great resource. You need to maintain contact with them, get updates, all of those things. So every once in a while, maybe the client contacts you on a weekend or it's late at night. So what are you supposed to do if it's the weekend or late at night and you can't contact your insurer immediately? Well, number one, take a breath and stay calm. Number two, gather some information. You can ask find out questions like, when did you first notice this was happening? Or is there any change to the property since I was there that helped you discover the issue? You can also come up with your own find out questions. Once you get a few answers from them, you just buy yourself some time. You can say, well, let me review my findings from the day of the inspection and see if there's anything that I notice. And just tell them that you'll be back in contact with. It's important in this situation that you don't mention your insurance. The minute that they believe that you're going to send it to your insurance, they're anticipating the insurance company is going to respond. So if you're utilizing our complaint resolution process, our pre-claims assistance, you want to avoid having them have the expectation that the insurer will respond because you're going to respond to them and we're going to help you through that process. So after the claims team gathers all of the information associated with the claim, they do a coverage review. So they're going to make sure that this is a situation that is going to be covered by your insurance policy. After that, they're going to help you draft a response. In most cases, it's a denial of liability, which is simply a letter that they draft that says and outlines why you're not liable. They're going to use your inspection contract, your inspection report, and any other evidence that they have to draft that letter. There are other situations like a reservation of rights. Maybe there's a portion of the claim that isn't covered by your insurance policy. The reservation of rights simply says, hey, we don't have to cover this issue, but we're going to continue to investigate and defend you in the situation. In a situation where this is a lawsuit, first, I want you to understand that lawsuits don't move quickly. Our claims team will do their best to stay in contact with you and keep you informed on what's going on. But as you go through the process, there's a few different dispute resolution channels that they use. One is mediation, another arbitration. Obviously, you can go as far as litigation, or maybe it's an early settlement. Sometimes it makes sense to do that. In the claims process, we see two possible outcomes. One of them is a non-suited claim. This basically means that the attorneys aren't involved, right? If a situation is non-suited, it's better for you and your insurance carrier because we don't have to pay the people in the suits to go to court for us. So something like arbitration or small claims court, or even our pre-claims process is a good example of a non-suited situation. The second is a suited claim. Most people think they don't have a claim until they have an actual lawsuit. Sometimes they take those demand letters and those types of things and they think, well, I don't have to do anything about this because the attorney hasn't called me. There are some basic steps to a suited claim. The first is a complaint is filed with the court. Okay, so the plaintiff or your client in this situation files a complaint with the court. The court then notifies you in the form of a summons. So normally you're served or something shows up to your office, and it's a legal summons. It'll break down who's filing suit against you, and who else is involved in the lawsuit. After that, your representation, your attorney files an answer to that summons. And then the plaintiff is given the opportunity to reply. If it gets to this point and the judge or the court decides that it needs to move further, then we move to discovery, where they really start to present all the evidence to the court. After discovery is trial. Now in home inspection, not a lot of cases get to trial. Most are resolved in other ways. As an insurance carrier, our goal is to avoid suited issues when possible because they're more expensive and the timeline drags out for a long time, causing you time and money away from your inspection business. I want to emphasize that you don't have to do anything wrong to be involved in a lawsuit. It's over 80% of the claims that we see come in that are entirely frivolous. These are things in your report, outside your scope of inspection, didn't exist at time of inspection, or just straight craziness. This is why having E&O, also known as professional liability, is really important. Your E&O is designed to protect you for errors that you make in reporting, omissions, or even defense for these frivolous or non-frivolous lawsuits. We'd love to help you protect your business. At Inspector Pro, we are experts in the inspection insurance world. Please subscribe to our channel for more risk management advice. We'll keep trying to make relevant content that's entertaining. And don't hesitate to reach out if you have any questions. If you'd like more information on how to deal with a complaint, download our guide, 7 Things to Do When You Receive a Complaint. The link is in the description. Until next time, stay safe, inspectors.